Donald Trump has failed. The presiding judge denying his latest Hail Mary attempt to delay his criminal trial in the hush money case in New York. The presumptive Republican presidential nominee's lawyers are trying multiple ways to delay. All of those motions are also expected to fail. Trump's first criminal trial is expected to begin on April 15th. In the meantime, in the Mar-a-Lago classified documents case, special counsel Jack Smith's team is holding nothing back. Prosecutors questioning whether Judge Aileen Cannon fully understands the case. In a new filing, Smith's team tells the judge that she is operating under a, quote, fundamentally flawed legal premise, one that had no basis in law or fact. Here's the issue here. In an order that shocked veteran legal analysts, the judge asked both sides to present possible instructions for the jury. Instructions, I should note, in which Cannon appeared to accept Trump's claim that he had the authority to take classified documents when he left the White House by declaring them to be personal. Prosecutors say essentially that's ridiculous. Highly classified government documents are not personal, and they tell her the Presidential Records Act she references has nothing to do with this case. I'm joined now by Brandon Van Grack, who is senior prosecutor for the Mueller investigation, also a senior national security official at the Justice Department. This is so interesting here. I have to ask, how unusual is it for a prosecutor to do something like this and just be so pointed in a filing like this with the judge?
It's unusual on top of unusual. Like the fact that we're talking about jury instructions in a case where we don't have a trial date, like that alone is unusual. And I think what you're seeing in terms of the sort of harsh tone in the government is the fact that the judge is asking for jury instructions on an issue that is dispositive. Like it actually, and the government says this, it would determine the case. You don't need instructions, just determine it.
That's right. So walk us through this, the jury instructions and what is happening and what this decision is.
Yeah, and so part of this is the frustration of rewinding, which is the issue before the court is an issue that the defendant raised, which is you should dismiss this case, dismiss it outright, because under this Presidential Records Act, removing these documents from the White House made them personal, and I cannot be charged. And that would be dispositive. The government actually agrees. If that is, in fact, the right interpretation, the verdict should be directed to the defendants. Rather than making that decision, the judge is sort of, I think, wrestling with how important that decision is. Because think about the other way, which is if the court rules against the former president, this has been his central argument in filings and in public, which is, I have the right to do this. And if she rules that he doesn't, then it deprives him of that argument. And so it's looking for some sort of Solomonic compromise. The court said, well, maybe we can handle this in the instructions to the jury. And what the government said is, there's no reason to do that. Just decide it now. So,
Brandon, why is this so hard for this judge in your interpretation? Is it because she's pretty new at this?
Well, yeah, I think there are a few things, which is part of this could be inexperience, but we are dealing with issues that very few judges have had to deal with before, period, regardless of experience. And so, I think it is important to take a step back, which is many of these issues are new or sort of rarely adjudicated. However, this particular issue is one where it seems pretty clear in the law, and factually, as the government paints, that there's no basis for fact. And so I think you're also just seeing the court wrestle with how important it is. There's no reason for the judge to rule on anything else. This decision is really dispositive, I think, to both parties.
How do you expect she will respond? How do you think she should?
Oh, Lord, hard pass on trying to predict what's going to happen in this case. But what I will say is, again, I think it's really important. There are many pending motions and issues before this court right now. Most of them are not dispositive. Should the former president get more documents? Should some names be redacted? It does not make any sense for the court to expend any resources or time in ruling on those if ultimately the court is going to decide that the president's interpretation is accurate. And that's what the government is saying. Just make this decision so that we can figure out what the next steps are.
The counsel's filing repeatedly floats this idea of appealing to the 11th Circuit if she rules against them. And if she doesn't move quickly, right, if she doesn't act fast here, do you think there's a chance the 11th Circuit could remove her from the case? Is that plausible at all?
Yeah, I think we're really many steps removed from that. Like, judges do get the law wrong. Like, it does happen. In fact, it happens all the time. Like, that is why we have an appellate process. So just because there's a disagreement between the Department of Justice and the judge is not a basis to remove a judge. It can be a basis to appeal it. And I think that's really been the focus of not only the filings, but the focus I think we'll see going forward.
Brandon Van Grack, thank you so much for taking us through this. We do appreciate it.
Thank you.